Afternoon. My name is Regina Hopkins. I am the Assistant Director at the DC Bar Pro Bono Center, and welcome to our webinar today on independent contractors versus employees, compliance issues, and best practices. Our presenter is Sedina Montani, who is a shareholder at Better Price. Sedina graduated from Western Michigan University and George Washington University Law School. She has been a specialist in the field of employment law throughout her legal career and has assisted us personally with a number of pro bono matters, and I know she works with others as well. So we greatly appreciate her willingness to come and speak to us today. A couple of housekeeping questions. If you want a copy of the slides, there's a PDF version of them in the interactive window on your screen. If you look down and see handouts, there is a copy of the slides that you can download. And in addition, if you have questions, there is a question box. You can type in your questions as we go along, and at a couple of different points, we will pause and answer the questions that you have. So with that, I turn it over to Sedina and let you begin. Thank you for being here today, Sedina.
And thank you for that introduction, Regina. Welcome, everyone. Today we're going to talk about independent contractors, which is a real hot topic. And so I'm glad to see that there are a number of attendees here. And as Regina mentioned, I'm happy to field questions. Today's presentation is intended to be a high-level look at the issues around independent contractors and what you can expect as you're looking through these issues. There we go. I was having trouble advancing my slides, so apologies. So here's just an overview of the topics that we're going to be looking at today. As I mentioned, this is a high-level overview. The idea here is to give you the tools you need to issue spot as you're working through entering into potentially contracts with independent contractors or looking at contracts you may currently have with independent contractors. I could give a half day or day long presentation on these issues, not to give you any ideas, Regina, but it's a really complicated set of issues here that, as you see, runs the gamut from issues stemming from the Department of Labor to the IRS. We'll talk through other state implications and the whole host of the spider web of issues that comes from this very, very complicated issue. So just to start, what's the background here? Why is this important? Why does this matter? Throughout today's webinar, I'll be talking about why it is that different government agencies care so much about this. And just as a baseline piece of information, it's important to keep in mind that we're talking about here the distinction as to whether folks are contractors or employees. So we really need to be thinking about this in terms of, well, what does it mean to be an employee? Since that is there's only two options here, employees or independent contractors. So before we think about defining independent contractors, it's critical to think about the definition of employees, right? So here I just have a little bit of information about what employees are, how they're defined under the FLSA and other laws. Important here is that they are generally outside, non-employees are outside of the protection of minimum wage, overtime, and anti-discrimination laws, and they're not subject to employee payroll tax withholdings and a whole other host of tax implications. And so because there's so many issues, which again I'll describe as we go through, all of these agencies that we talk about in state and local agencies are really interested in the distinction between independent contractors and employees because they're potentially viewed as an avenue through which entities, for-profit companies, nonprofit companies, and others can potentially, I have the term cheating workers, but that's how a lot of agencies view the work around the classification of individuals as independent contractors instead of employees. In recent years, it's been a really hot priority issue for the Department of Labor, slightly less so in the current administration, but that does not mean that the issue has cooled off in terms of litigation that's being pursued, or again, it's state and local agencies. I have flagged here the Department of Labor, the IRS, and the EEOC as agencies that are skeptical of the independent contractor issues. It's not just those agencies we're talking about here. When we think about the distinction between an employee an independent contractor. The risks are there's tax issues to keep in mind, whether it's federal, state, or local income taxes, Social Security taxes, Medicare taxes. These are taxes that employees and employers need to pay in that relationship, but not necessarily in the independent contractor relationship. There are unemployment tax issues. There are workers' comp issues, the issues around overtime and minimum wages, unpaid work-related expenses, which are specifically required in some states, for example, California. Issues around with if you have someone misclassified as a contractor instead of an employee, you could be inadvertently not following the DC laws around required paid sick leave, for example. There are also ERISA issues, healthcare, Affordable Care Act issues, disability insurance, life insurance, 401k contributions. So the list goes on and on in terms of the implications of classifying an individual as a contractor instead of an employee. So let's start here with the Department of Labor. Why do they care, right? We're starting here because minimum wage is a pretty basic requirement, and I think that's something that all of us generally have our hands around. Keep in mind that the Fair Labor Standards Act, which is the primary piece of legislation that the Department of Labor is concerned with when they're looking at wage hours issues, it defines employee very broadly. It has perhaps my favorite line in any employment-related regulation, which I know is incredibly nerdy to say, but it defines work as an employee as someone who is suffered or permitted to work, which is just such a lovely antiquated turn of phrase. It's a pretty broad phrase, and throughout the 70, 80 years of existence of the FLSA, it's been interpreted by courts and in regulations incredibly broadly. And so, when we're talking about what it means to be an employee, the Department of Labor takes that definition to be incredibly broad. So again, because what we're talking about here is one of two alternatives, whether someone's an employee or an independent contractor, super important to keep in mind that the definition of an employee is very, very broad. I want to provide some information on the Department of Labor guidance that was issued in 2015. I'll talk in a moment about the fact that it has been withdrawn, but that doesn't mean that it's not still useful in terms of putting together best practices. I also think it's still going to inform the way that that courts and state and local agencies look at these issues. I also think it's very likely that if the administration changes at some point in the future, these types of guidelines, even if it's not the specific set of guidance, may likely come back into play. And again, when you're thinking about best practices, this is something that's important to keep in mind. The important piece here, in addition to the 6 factors that I have laid out, which I won't read out loud for you, but the important piece here is that the working premise of this 2015 guidance is that most workers are employees under the FLSA because of that incredibly broad definition that I just referenced. This is a standard premise under state, under local laws, and other agencies and throughout the case law. And so that's really something to keep in mind here when you're making a determination as to whether an individual or a position is appropriate for treatment as an independent contractor or as an employee. It really should be your premise that you're starting with the assumption that they should be an employee unless you can make a case that they instead can be an independent contractor. If any of you have participated in similar webinars I've done with the DC Bar on the issue of exempt or non-exempt employees, it's the same kind of analysis when you're doing a classification to determine if a position should be paid overtime or should not be paid overtime. Start with the premise that the position should be paid overtime, or here, start with the premise that the individual should be an employee and convince yourself that they actually can be an independent contractor. The critical piece of the 2015 guidance was whether the worker was economically dependent on the organization or really in business for him or herself. So what does that mean? Well, by way of example, if you have someone who is providing contracting services for your organization on, a 10 to 15 hour a week generally basis, but you know that they're doing the same thing for 2 or 3 other entities, and they have marketing materials and they're out there pitching to do the same kind of work for other clients, and they really do have their own business, that's going to cut pretty hard on the side of being someone who is not economically dependent on your organization. On the other hand, if you have a contractor, and if we were doing a webinar with video, you would see that I had just used the air quotes there. If you have a contractor who's at your location working 40 hours a week and has nothing else going on besides what they're doing for your organization, and we'll talk about the general principles, but in terms of the 2015 guidance and what they were really going at was whether the individual was really in business for him or herself. If they're spending all of their working time working for one entity, the answer is probably no. So as you'll see here, the guidance was withdrawn. It was withdrawn last summer. This guidance was never binding law, but it certainly informed, obviously, what the Department of Labor was doing. It informed how agencies were conducting audits at the state and local level. It informed case law, and in some cases, the case law that it informed has already been decided, right? And so there's already judicial guidance that's consistent with this. So this is not dead by any means. Although I will note when they withdrew it, they made a point of specifically withdrawing the presumption that that individuals are employees rather than contractors. I would just warn that from a best practices standpoint, I still very strongly urge you to come at this issue for each contracting situation with the assumption that the person is or the position is an employment situation, and then make sure that you are comfortable that you can get into the space of the independent contractor requirements before you inadvertently get into some hot water. So with that, I want to move on to talking about the IRS and why the IRS cares and what we should be thinking about here in terms of these implications, and how you'll see as we start talking about the IRS how the misclassification of individuals as independent contractors rather than employees can really have much larger implications than just, are we treating this one individual or this category of individuals fairly? It can lead, in the IRS context, it can lead to an increase in your risk that you will get audited. There are a whole host of taxes that are associated with this. So it's risky business whenever you get on the wrong side of the IRS. I offer all that knowing full well that the IRS is not particularly fully staffed these days and is certainly working hard to get by on what they have. And so I understand that it's unlikely that a smaller entity is facing a huge audit risk. All that said, it's my role generally and today on this webinar to be the nervous Nelly. So I will play that role and warn you that that's one of the things that can come from this classification. So on the next two slides here, I have the 20-factor test that the IRS previously used when they were looking at whether an individual or a category of individuals should be an employee or an independent contractor. I won't read these to you. We'll go through some of these factors as we're discussing how the IRS currently analyzes the issue. I think it's important to see these tests, though, or the factors, excuse me, because it really exemplifies the whole host of issues that you need to be thinking about when you're determining whether a certain situation is appropriate for a contract as opposed to an employment relationship. When the IRS was using this test, and I know that the test has been and I think is still used by some local agencies. I had an audit with the DC Office of Employment Services that, if we have time to, I'll walk through a case study on that one at the end of today's webinar. But I know from my recent experience with the Department of Employment Services, that they appear to still be using this 20-factor test, even though the IRS is no longer using it. And so it's the other thing that's important, and seeing all 20 of these, I think, is really, visually kind of remarkable to see that there are 20 of these. The way that the IRS has interpreted this, and the way that the Department of Labor with its tests, and that local agencies and the courts have looked at these various factors, whatever they may be called, is not to say, well, here are 20 factors. If you have 11 of them pointing in one direction, then that means that this is an independent contractor. If you have 11 pointing in the other direction, it'll be an employee. This is not, there's no hard and fast rule here in terms of how many of these factors you need to have pointed in one direction or the other. It really is a fact-specific analysis. So thankfully, the IRS recently tried to simplify their test, and from 20 factors, we have gotten only 11, which 11 is still quite a bit, but it's better than 20. So we're going in the right direction, I think. These factors fall into three main themes, each of which I'm going to walk you through so that you have a good understanding, and I think it will hopefully exemplify how this really is a fact-specific analysis. There's no magic here about the number that you need to have or which ones are more or less controlling, although a few are pretty red line or pretty red flags, and I will certainly point those out for you. It's balancing how all these factors work together, and based on the whole analysis of the entire working relationship, will the IRS and other agencies that rely on this and other tests determine whether a position is appropriate for a contracting relationship. I'm going to take just a moment to pause and have a glass of water before I move on. Give me just a moment. Okay, so as I mentioned, actually, let me step back. The last point on this slide is important. There have been, as you saw with the Department of Labor guidance that was issued and then drawn back, all of these agencies kind of move a bit with the politics here in D.C. and the pendulum swings in one direction or the other. The economic realities test that the Department of Labor used to use is now, it looks like, where the IRS is morphing into. So I mention that because it's a good example of the ways in which the various entities that look at these issues kind of borrow from one another and look at the factors that each of them have put forward as determinative. Courts look at all of these, and so this is a good example of how the process bleeds over from one agency to another. The analysis bleeds over from one agency to another. Okay, so let's start with behavioral control, this first category that I noted here, that the 20 factors are really, when they were culled down to 11, they are trying to get at three main themes. So the first is behavioral control. What does that mean? That means who is controlling the individual, the worker, I call them here. Where and when are they doing the work? Is this work that they could do at 3 in the morning from Miami, or do they need to be sitting in your offices starting at 9:30 in the morning, Monday through Friday, providing these services? Whose equipment are they using? Are they using their own computer? Are they using their own internet service at home or at a work share location? Or again, are they planted in your offices, or have you issued them a laptop or other devices to do the work? This is a great example of one factor that in different situations can look bad, and other situations is perfectly defensible. If you were dealing with really confidential information or systems that need to be on a device, or if they're licensed and you only have so many licenses for this software that the contractor needs access to, or if they're in the government contracting space, I suppose if you had someone who was dealing with classified information and they needed to either be on site or they needed to be using a secure device, there are certainly fact-specific reasons why providing a contractor with devices, hardware, computers to do the work would make perfect sense, and in every single situation you would need to have them do that, and so it wouldn't necessarily be a problem. However, if you combine this with the fact that, as I mentioned, the person is being required to be on site, specific hours, they're given a company computer to use. If you go through some of the other factors here, they're the ones that have to provide the work. They can't kind of contract it out. There are specific processes or orders or sequence that the work has to be done. all of those factors combined with the fact that, for example, the individual is being provided, with a company computer to use, that's going to start to holistically look like a situation where the behavioral control really does rest with the contracting entity, meaning the organization, not the employer, rather than the individual. So it's really how all of these issues interplay with one another, so you can determine whether the behavioral control rests with the contracting individual, whether they really have control over the way that they perform the work, or if that's being controlled instead by the entity. So financial control, this is the second bucket, if you will, of factors that the IRS is looking at now. And there are a whole host of these. Some of them relate to the factors we just talked about for behavioral control. For example, the extent of the worker's individual investment. That's a great one to follow on the computer example. If the contracting individual is required to purchase and maintain, their own computers or devices with certain specifications, but they're responsible for purchasing them, and they actually have the ownership over them and have the ability to use that device for other purposes, if you will. That's going to be a factor that the IRS will look to under the financial control bucket, even though it obviously relates to behavioral control as well. The first bullet point here is one that I see all the time, is especially with smaller organizations or nonprofits. This is an example of no good deed going unpunished. If a worker is getting reimbursed for business expenses, this is one of those factors that on its own is going to raise some pretty serious red flags. It seems like an appropriate and nice thing to do, right? You have someone who's doing important work for you, and they have business expenses that they're spending on your behalf. If the run-of-the-mill business expenses like airfare or mileage or home internet, those types of things, if those are being reimbursed by the organization, that is in most cases going to point pretty strongly towards an employment relationship rather than a contracting relationship. This is an easy one to fix, though, right? Because this should be something that you spell out in your contract. And if it's the case that you foresee that this contract will require a fair amount of travel, and you want to make sure that the individual is actually, this is financially worthwhile for them, but you don't want to be, having them submit meal and parking stubs from the airplane tickets. There are ways to contract around this to make sure that they're not being reimbursed. You can either increase the amount of their contract to cover travel costs and let them decide, if they want to fly first class, and they can do that, that's on their own dime. If they want to take a Greyhound and spend 2 days traveling on their own dime, that really speaks to the financial control, right? In terms of, you also, and I've seen this with some entities, if they have their own kind of robust travel system because they have a lot of travel as a part of their work generally, and there will be travel involved, they sometimes will make travel arrangements for a contractor. I know this seems like a distinction without a difference, but it's certainly something that the IRS would look at differently than the individual making their own plane ticket and then getting reimbursement. The extent to which the worker makes his or her services available to a relevant marker, that's really important. And I mentioned that a little bit earlier, because if an individual is spending all of their working time working for a single entity, it very much points in the direction of an employment relationship rather than a contracting relationship. But if instead they're marketing themselves and doing the similar work or related work even for other entities or attempting to, that is something that the IRS would look to show that they actually are more of a contractor than an employee. Okay, and then the final bucket here is the relationship of the parties. There are a whole host of factors that the IRS and other entities will look at here that fall under this category. The first is the terms of the written contracts. That's an important one I want to unpack just a little bit. First, even if you have a contract that says that the relationship is a contracting relationship, that does not make it so. You could also call the contract an elephant, and it will not make it an elephant. So while it is incredibly important and required, I would say, and virtually every instance that you have a written contract with a contractor, that is not going to be something that makes a contracting relationship appropriately a contracting relationship rather than an employment relationship. On a related note, although this isn't on here, it's just a little bit of a divergence here. Something else to keep in mind is that even if an individual wants to be a contractor rather than an employee, that does not make it okay if otherwise it should be an employment relationship. Whether the parties want it to be a contracting relationship is not anything that the IRS or the Department of Labor or any other agency or court will look at when determining whether it's appropriate. There are benefits in many cases for both sides of the contracting relationship if it's a contracting relationship rather than an employment relationship. Mostly they have to do with taxes. And so this is why so many government agencies are so interested in this, because there are a whole host of taxes and fees that are associated with the employment relationship that you otherwise could get around if everyone were just a contractor. So I offer that because I often hear folks say, well, I know that this is probably more appropriate for an employment relationship, but the person really wants to be a contractor. And so, we thought that we should just do what they want. You should not do what they want. You should do your own analysis. The organization will be facing significant risk if it does this wrong, and so it's super critical that you go through this analysis and make sure you are handling it appropriately. The permanency of the relationship is also an important one. I have had situations where I learned that one of my clients has had a contractor, again, if we were on video, you would see me using air quotes again, a contractor who has been working with them for 3 years. That is not a contractor in most cases. If you have someone who you contract to do web design, or you contract to come in and water the plants in your offices, which is actually a contractor we have here. Those are contracting relationships that are fine to be ongoing. They're sending you invoices, they're doing specific projects. But if you have a situation where, consistent with the other factors we talked about, you have a person who shows up at your location or is doing regular work on an ongoing basis, just, is the end of most job descriptions say other duties as required. If you have an other duties as required in a contracting relationship that's going on and on and on, you need to be very, very wary that's appropriately classified as a contracting relationship. This final point is important and I think a bit tricky, and it's that the IRS will look at the extent to which the services that are being performed are a key aspect of the business of the company. So I mentioned web design. I mentioned watering the flowers. For a law firm, those are not issues that are critical to the services that we otherwise provide to our clients, the business that we're otherwise operating in. If there were a contractor who were sitting in the office next to me providing legal services to our clients and otherwise was doing the same kind of work I'm doing, the nature of our business, providing legal advice, that in certain circumstances would be a problem, and it's one of the factors that would be looked at in this relationship of the parties bucket. Okay, so I have mentioned a number of times the reference to state and local jurisdictions and the tests that they use. Those, as with many, many employment-related issues, the state-specific issues are not necessarily the same as the federal guidance, and in many cases, especially in this area, are much more restrictive and onerous on entities, employers, companies, organizations than they are under federal law. So, for example, Washington, D.C. looks at the relative nature of the work, which is similar to the tests that we've talked about, and really looks at, in addition to those factors that I just discussed, the selection of the individual, what the process was for hiring them. Did you have an interview process that looked like how you would interview an employee, or did you release an RFP, for example, and seek solicitations from a number of entities? How are you paying them? Are you paying them on an hourly basis for the number of hours that they worked, or are you giving them a flat fee? Now, that on its own is not necessarily determinative, because there are some hours, there's some work that is appropriately contracted out on an hourly basis. For example, I'm a lawyer, and my clients get a bill that has, in many cases, the number of hours that I've worked on a specific project. I'm not their employee, but all of the other factors around the relationship makes it clear that they're contracting with my law firm to provide these services. Everything else points to a contracting relationship. So that's not going to be determinative. But again, if you have all of these factors that are pointing towards or leaning towards an employment relationship, and you're also paying somebody by the hour, that's a red flag. Other factors here to keep in mind is this last one is similar to what we just talked about, is whether the service performed by the person is part of the regular business by the one that's hired. If we have time, I mentioned I have a case study. This is a factor that came up in the case study that I recently resolved with the Department of Employment Services. So again, not on its face determinative, but has a lot of weight when DC is looking at these issues. Okay, so I've mentioned that there are a lot of tax issues at play here, and I have speculated that this is a big part of the reason that governments are so interested in this issue. I thought it would make sense to just very briefly walk through what the differences are if the individual is an employee versus as an independent contractor, because I think that this helps kind of flesh out why it is that this is an issue that spiderwebs out and touches so many different potential risk points. If the individual is an employee, the organization is required to pay Social Security taxes. The organization is required to pay Medicare taxes, unemployment taxes, must issue a W-2 wage and tax statement. Whereas if the individual, I think I missed a slide there. My slides were in the wrong order. I'm so sorry about that. So I started on this slide. This is what the individual must, or the organization must do if the individual is an employee. The organization must also withhold income tax, must withhold the employee portion of the Social Security taxes, and must withhold the employee portion of the Medicare taxes. So these are the issues that employers need to be thinking of, or organizations need to be thinking of course, if you have an employment relationship. Contrast that to if you have an independent contractor. You're paying generally lump sum payments. There are no withholdings. So these withholdings that I showed here on slide 18, those are not withholdings that come out of an independent contractor relationship. So you can see that right off the bat, we have income tax, Social Security, and Medicare. Those are three very important buckets of taxes that are not being withheld from the independent contractor when they're being paid. And of course, rather than issuing a W-2, the organization would issue a 1099. So when you have an independent contractor relationship, it's the onus shifts onto the individual to pay the income taxes and the self-employment tax rather than having those things automatically withheld from their paychecks. Clearly, it is organizations and companies are generally going to be more likely to make sure that they're withholding taxes, whereas an individual might be more inclined to say, I don't believe in taxes, I don't want to pay them, I'm not going to report them. So the likelihood of these income taxes and self-employment tax not being paid by an individual is substantially higher than an organization failing to withhold these taxes. And workers may deduct significant business expenses. So if you have an individual who has a home office, for example, they can, and this is, I'm not giving tax advice, I'm giving a little asterisk here for this piece of it, but they can generally deduct, their home internet service, the space, if it's a dedicated space in their home, their computer equipment, their office equipment, that is furniture. And so there are a lot of deductions that make it beneficial in many cases for individuals to be contractors rather than employees. This is another way that revenue is lost as a result of this relationship.
So Dina, can I
so let's talk? Of course, Regina.
Weigh in just a little bit. First off, you mentioned that the IRS doesn't have a lot of money or staffing, that they've been sort of short-staffed for a while, but it's my understanding, and someone once told me that, you know, you have a former employee walk into an employment lawyer's office with a discrimination case and they walk out with a wage and hour claim. You know, and that's how a lot of this comes up. You terminate someone's services, they say, this is unfair, they go speak to a lawyer, and it's a private lawyer who says, well, you know what, you were really an employee, you weren't an independent contractor. And that's how a lot of this litigation comes up. Would you agree with that, or is that your experience?
I agreed with that, and I actually launched into this next page because it was as if we had planned this, which I assure everyone we did not, but that is absolutely the case. The likelihood that this is going to come up because you have a Department of Labor or IRS audit is very low as compared to the risk that Regina just mentioned, which is the potential for civil penalties and damages, class action lawsuits. That's a much higher risk. You are absolutely right that the easiest way that a plaintiff's employment attorney can find an action against a former employer or, you know, an entity with which a non-employee has contract in this case is by looking at wage and hour issues for a couple of reasons. First of all, they're easier. It's about math, and despite all of the jokes about lawyers being terrible about math, much of which are true, it's easier to prove than, you know, what did Mary mean when she said this to Sarah in the hallway 3 years ago, which is what a lot of discrimination or ADA or other types of more complicated claims relate to, right? So they're easier cases. There are also a lot of really cut and dry penalties associated with them under state and federal law. So it adds up pretty quickly. Employers are terrified of them. And the wage and hour laws are really complicated, right? I was just on a call with a client earlier today, and we were walking through a whole bunch of their processes around timekeeping. They're a super sophisticated entity, and they were doing something very, very wrong. And not because they were trying to. The laws are just really complicated. And so the plaintiff's attorneys know this, and so I've always assumed that there's a checklist that exists that I've never gotten my hands on of questions to ask someone when they're coming in the door to figure out how you can sue their former employer. If that checklist exists, wage and hour issues are pretty high on it, and wage and hour issues and missteps associated with misclassification of an individual as an independent contractor rather than an employee is incredibly simple to prove if you can just show that the individual should have been an employee.
Okay, and then I just want to weigh in on one thing myself personally. I've seen a number of instances where nonprofits have tried to characterize their executive director as an independent contractor, and this gets back to that test you talked about of how essential are they to the organization, and I think that would be a really difficult one to sustain for that reason. You know, an executive director is pretty critical to an organization, and I think the people, the relevant, whoever you're talking to, whether it's an attorney or a private bar or a government agency, they're gonna really be dubious about that. So that's the problem. Okay, so with that, I turn it back to you.
Yes, I agree. That is a big problem. That's a question you've never called me with, Regina, and that's because it is incredibly self-evident that if you have an organization that's paying its ED or someone else who's kind of at that level of visibility and import to the organization as an independent contractor, you're really setting that organization up for risk.
And I'm going to have one more question, because someone just did it, and I had it on my notes, but I was going to skip over it, and then someone came up with a question. They have a not project-specific worker who is part-time, and or you're hiring from a specific period of time. Like you get a grant, and you only have a funding assured for a year for a particular project or a particular initiative, and so you hire someone for a year, a temporary worker. You know, so how does that sort of fit into this? Because a lot of organizations who get grants will post a job as a temporary or a time fixed employment. So how does that fit into this?
Well, and that phrase that you used at the very end is how it should unfold. it should be a time-fixed employment, right? So whether someone is only working 15 hours a week or whether they're only working for 6 or 8 or 12 months, if we go back to some of the factors that we looked at here, the duration of the engagement was one of, 11 that the IRS pointed to? Let's see. Now I'm back in it and I shouldn't have gone. The factors are in there. That's one of many, many factors to be considered, right? So it may be the case that when you're looking at a relationship, it's that the person is hired to work on a very specific project, to do something that's kind of out of the norm for an organization. You know that it's going to be funded for a very limited period of time. They're going to be doing it remotely from Montana. They're using their own computers. You're going to pay them on a fixed fee basis. You have to look at it in the totality of the circumstances, and I get this question a lot as well, Regina. Just because you know that the position is not going to be available for the long term does not mean that it's appropriate to bring that person on as a contractor necessarily.
Thank you.
Oh, okay, great. So here on go ahead. Oh, that was the last question, or you have one more?
No more.
Okay. All right, so let me very quickly note there on the next couple of slides. I have some of the risks associated with this. We've talked about these throughout the course of the presentation, so I will leave these here for you to review. And then there's some mention here of the IRS form determinations, which is the IRS audit risk that I was mentioning earlier. I also want to move to some of the other maybe unforeseeable impacts or risks associated with misclassifying an individual as an independent contractor that you may not think about when you're thinking of why this is important. This is the spider webbing portion of the webinar. There are certain state-specific employment requirements that you might miss. For example, the DC Wage Theft Prevention Act notice, which is that notice that you need to provide to everyone at the time of hire and whenever their salary or their pay changes. I know this is an issue near and dear to Regina's heart. We talk about it all the time. And if you don't know what that is, you should Google it and or reach out to Regina or me, and we can provide you with that notice. This is just an example of one of the small things you might not be complying with if you are misclassifying an individual as an independent contractor. Smaller organizations also could unknowingly become subject to certain laws that they thought they were exempt from because of their size. I think the one that's most critical here is the Family and Medical Leave Act, which covers organizations if they have more than 50 employees in a 75-mile radius. If you have 45 employees and you have 10 contractors who are misclassified and they're found to be misclassified, guess what? You have been depriving your employees of access to or protection under the Family and Medical Leave Act, and you could be in some serious hot water there. There are also impacts with the Affordable Care Act because there are different obligations based on the number of employees. So this is, it doesn't just have to do with who's paying what taxes to which government agency. There are also other laws that are implicated that relate to employment issues that you should be mindful of when you're thinking about these classification issues. So here are some common mistakes that I see regularly with, frankly, entities of all size, and in private sector, in the nonprofit sector, and in for-profit entities. And I'll walk through these very quickly. The first is over-relying on the representations in the agreement. That goes to something I spoke about just a few minutes ago, which was even if you have a contract that says we agree and we promise and we have engaged in, we've done a little ceremony that promises that this is a contract relationship, it's not an employment relationship, that's not going to save you. This is the second point is the issue that you raised, Regina, the misconceptions about short-term employees. We've talked about that. The overlap between independent contractors and employees' responsibilities. This also goes to that same kind of principle, which is, and one that we've spoken about just a few minutes ago, is what kind of work is the individual doing for the organization? If they are sitting alongside your employees and you only have that ticket, if you will, for that FTE for a year because of a certain grant, and you have them on a contract basis, but otherwise they're doing the same work that your employees are doing, that's going to be a real serious issue. There are also joint employer relationships to be mindful of. It could be the case, and I know that bigger entities maybe deal with this a little bit more, but if your organization contracts out to have, for example, someone use an outside service to have a receptionist answer phones and greet people at your office, and you have a contract with the entity, they're employed by the other entity, and they're definitely it's a contract situation. But if they're actually on site, you could have some liability under discrimination or other laws, and so that's something to be mindful of here. We don't really have time to go down that rabbit hole, but I want to flag it for you, and certainly give that some thought if you contract with other entities who you think are actually employing the people who are there working for you. Having mandatory work hours is a huge red flag. If you have a contracting relationship that says, you have to show up at our offices and be here from 9 to 5, you would be hard pressed to show with the other factors that this is not an employment relationship, because showing up is there's some cliche, right? Showing up is half the battle, or 90% of every job, or whatever the case may be. If you're having someone show up on specific hours, then you're probably looking at an employment relationship. If you have a non-compete clause, I've seen this in a number of independent contractor clauses, more obviously in the for-profit space. But if you're hiring a contractor and you say you can't work for our competitors, you are really undercutting the principles that we saw with the Department of Labor and the IRS, which is whether the individual has the economic control to over their business to work for other entities. So that's a big red flag as well. And then finally, lack of internal consistent policies. This is kind of across the board, and I would say if you're dealing with any kind of employee or individual related situation, the need to be consistent in the way that you're treating individuals is just incredibly important. And so if you're treating, this also speaks to some of the other factors we've talked about, but if you're treating one individual as a contractor, one as an employee, and you change that throughout time, and you kind of go back and forth between them being an employee and a contractor, those inconsistencies are alone going to be red flags that will give a plaintiff's attorney or a state or local agency that has more bandwidth than the IRS potentially real pause when it comes to looking at your working relationship with that individual. Okay, so I have a few slides that I'm going to leave here, and I'm going to really not discuss because I don't think that they're applicable to the group that we have today. But because the gig economy is such a hot topic right now, I thought I would be remiss not to provide you with at least some overview of what's happening in the case law as it pertains to Uber, Lyft, and all of the folks who bring us our groceries and food on a regular basis. This and the next couple of slides are just reference materials for you. I certainly would welcome any questions on these topics. I just have known in the past that when I've provided this information with nonprofits, even if it's not necessarily appropriate to their business, everyone still wants to know what the heck is happening with Uber. So on this slide here, this is a great example of the ways in which various state agencies look at these issues differently as it has played out here in these 3 different jurisdictions. So here in California and Oregon, they found that Uber drivers are employees, and in California and Oregon, yes, they found that they were employees, and in Florida, they found that they were not employees. So not a lot of consistency there, but just goes to show you that we need to be thinking about this not just from a federal standpoint, but also from a state-specific standpoint, and looking at the states in which you might have folks doing work for you. Here are some other case law examples for you. This one that's pending in this O'Connor versus Uber Technologies is really interesting because the parties came to a settlement, and the court said that $100 million is too favorable to Uber and not favorable enough to the individuals. So I read that as a pretty clear sign that they're going to find that those folks are employees and not independent contractors. Pretty aggressive. On the other hand, and all of these cases I should mention are in the Northern District of California, for Grubhub, the court found that folks were appropriately classified as independent contractors. Now, obviously, the difference between Grubhub and Uber, they're pretty similar business models, but there are some very wonky reasons why it turns out that the court found that Grubhub folks are not employees and the Uber drivers were. There also was a really recent case out of Pennsylvania that spoke to this, that found, and this dealt very specifically with Uber Black, so the limousine folks, because you see in the bottom, they were able to decide when to work, they're free to nap, run errands, or smoke cigarettes between rides. So again, different jurisdictions coming down very differently on the same types of relationships. So with apologies for going very quickly through that piece of it, I wanted to make sure that we had enough time to talk through some practical advice and some takeaways that I hope you all bring from today's webinar. The first tip that I have is to audit the folks that you have who are currently contractors. With all of these things in mind, go back and take a look at those contracts. Do you have contracts with folks who are still doing work from you that were signed in 2014? That's probably something you want to take a look at. And given all we've talked about, it may be that you determine they are contractors, but it's probably a good idea to renew that contract, to look at it with fresh eyes and make sure that it's actually appropriate. The third point here is really important. Reviewing the realities of the arrangement and the work that's performed. Does the contract really match what's happening? This often happens when you have kind of an ongoing relationship with a contractor. Even if it's the case that the contractor actually is appropriately a contractor, you need to make sure that your contract matches what you're actually doing. So take a look at that. That may warrant entering into a new contract, given what's actually happening. Keeping in mind that all of these are really, really fact specific, and that when it comes to the first document that any entity or lawyer is going to look at to determine whether this is a contracting relationship, it's going to be that contract. So you really need to put your best foot forward and make sure that it's not something that's, a one-pager that doesn't have any of the appropriate language, which we'll talk about, or isn't really robust in terms of describing the relationship. This last point is incredibly important, and I've seen it. I've seen it over and over again. The idea that this is how it's done in our industry, or this is what our colleagues are doing, or this is what our competitors are doing, that is not an excuse. We talked about a whole host of factors, and I'm sure that you did not see on any of those lists that other people do it this way. So it's tempting, and it sometimes means that if you are doing it the correct and lawful way, it is more expensive for your organization than if you're paying someone as a contractor. That is a factor for you to consider in making a reasoned business decision, but that is something that you should be considering very, very strongly, and being mindful of the fact that that just because someone else is doing it, as my mother told me when I was growing up, does not make it okay. So some of the must-haves for your contractor agreements. It would be rude of me to say to you, you need to audit your contracts and review them to understand that to make sure that they're appropriate, without giving you some advice on what they should have in them. So this slide here is the must-haves. Obviously, you need to have a written agreement signed by both parties. You need to clearly define the scope of work. What are they actually doing for you? And defining it in a way that will make clear when someone else is looking at it that, oh, this is different from the standard work that this organization does. This isn't just that they're having them do the same thing that another employee is doing. They're actually doing something specific and discrete and that's appropriate for a contracting relationship. The contract should make clear that it's the worker who is deciding how the work is being performed. You should require invoicing. I know that this is a headache, especially if you're paying someone on a monthly fixed fee basis. You think, Sadina, you just told us that we should not be paying someone by the hour in most cases. We should be paying them a fixed fee. Why in the world are we getting invoiced? Well, I don't make the rules, I just tell you what they are, and invoicing is another really important way to demonstrate that it's very easy, that lawyers and agencies will look to see if you're actually paying for services rendered, right? Are they actually performing those services for you, or are you just paying them a salary, right? What's on the invoice? It's a hassle for individuals, it's a hassle for organizations, but it's really something that you need to require, and I think also your auditors will thank you for that as well. The terms need to be clearly defined, and I always recommend that you have limited termination rights. You should not be putting in a contract that this is an at-will agreement. You shouldn't be using the same language as in your employment manuals. That is important language that I would recommend that you have 17 times in an employee manual, but should show up 0 times in an independent contractor contract. So very important. And the final point, even though I have said many times that the terms of the contract do not make this an independent contractor relationship, you still should include that language in the contract to make it clear to both parties that that is what they are signing up for. Good to have. So these are the must-haves. Here's the good to have. I recommend strongly limiting the amount of training or information that you are passing on to the individual to allow them to work for your entity. Some of that is certainly necessary, but I would steer clear of doing the same kind of training that you do for employees when they're being onboarded. Set up a different process for contractors if you use them a lot. Don't give them your employee handbook and say, this applies to you, you need to sign it. If there are certain policies that you want to apply to them, like, for example, an anti-harassment policy to make clear that there's a requirement and expectation that they won't be harassing your staff members, you can have that as kind of a standalone, but you can't just give them your employee handbook or do the same kind of training you would for employees. It's great to have the employee or the worker decide when they're going to do the work, where they're going to do it. Ideally, they'll they'll provide their own tools and equipment. They should have the freedom to contract with others for their services. Now, there are some projects that are so fast and so onerous and so labor intensive that it may be the case that you say, this is going to require 60 hours a week for the next 3 weeks for you. That is, again, a fact-specific analysis, but for the in the most instances, you're going to want to make sure that they have the freedom to contract with other entities. Their compensation shouldn't resemble a salary. That speaks to the invoicing point I mentioned before. Termination here should be not just an at-will situation. You should actually spell out what breach of contracts will warrant immediate termination. You should also spell out the terms so that, this contract will be in place for 3 months unless the parties renew, those types of things. And avoid circumstances here is the last point where the contractor position is identical to those of the W-2. The W-2 employees, excuse me, again, for purposes of showing that the work they're performing is different and apart from what you would otherwise hire an employee to do. This is an important piece of that puzzle. So with that, it looks like we will not have time, unfortunately, to go through the case study. I appreciate the questions that you asked, Regina, and I want to make sure that we have time for folks to ask questions for the last few minutes of our time together today.
Okay. A couple of them, you mentioned not paying people a salary. Someone asked, is that a red flag to pay an independent contractor a salary? And the answer from what you just said is yes. That's a big problem. Then someone asked. It is,
but I wanted to add just a finer point on that. This is one of those areas where how you describe it matters, right? So if you're paying someone a retainer fee of $3,000 a month, which sounds a whole lot like a salary, but you're paying it once you've received an invoice from them, and it's pursuant to clear terms in the contract that call it a retainer, and there's, you framed it in that way, even though ultimately paying someone a lump sum sounds a lot like a salary, that on its own is not necessarily a deal breaker. Does that distinction make sense?
Yeah, the only thing I would ask is, the thing about a retainer, though, is you have to pay it whether, they're there for 10 hours or 30 hours, as opposed to a salary where you're paying them, where you deduct for not showing up or not being there. I would think that's right.
That's right.
Yeah. This I used to get all the time when I was general counsel, and so I think it's good to address it, which is, someone has been working for you and now they're leaving, but you have work that you still want them to do. So people sometimes want to change them to an independent contractor, and they're going to do maybe a part-time job. And sometimes it's exactly what they were working on before they left as an employee. And so someone asked about the change from can you change someone from an employee to an independent contractor if you're still paying them and they're doing, and particularly if they're doing work that's almost the same or very close to what they were doing as an employee.
Yeah, I have seen a lot of those situations, and they can be done correctly. They're not, just on their face unlawful. It's incredibly important to make sure that you have a really, really tight contract in that case, so that it doesn't just seem like this person's retiring, and so now all of a sudden they're getting maybe they're accessing pension or Social Security benefits, but they're also on the side, pocketing a lump sum. So it's a retirement in name only. But if you want to have someone continue on as a consultant to provide project-specific transition help, that's certainly something you can contract into, and I would say there are a lot of things you'd want to make clear in that situation. You'd want to make clear the types of projects that they agree to be called on for. You'd want to make clear that you're going to pay them either an hourly or a daily rate. So if you require them to come in and meet with folks for a day-long set of meetings to help with the transition, that you're paying them a flat fee for that they're invoicing you, that you're not guaranteeing them any amount of hours, and then it's not just, I would avoid the dreaded other duties as needed. This is just an area where I would say folks need to work with an attorney to get that contract drawn up as tightly as possible, so that you can point to that and make it clear that they're not just continuing on as an employee, because this happens on a regular basis and is understandable. But also so that you're making clear to all of the stakeholders what is expected of the individual, right? That this person is not an employee. You can't just email them and expect them to, jump when you reach out, that there are clear expectations around that relationship. And the only other point that I would add here is that I would, and this seems like semantics, but I would not allow them to continue to have a company email address. They should have their own either personal or ideally business email address that is, me, Sedina@montani.com, right? That's their own email address, so they're not still using your system. So set that up mindful of the other factors that we walked through. It can be done. You just need to be careful about it.
I was going to say, speaking as a tax lawyer, I know the IRS is, we talk about how skeptical they are. They're really skeptical in those situations, so you do have to be very careful. Training and education. Someone said, what happens if you have someone come in as part of a training or an educational, like an intern, and you offer them a stipend? I'm going to just not put you on the spot for that, Sedina, only to say we have a podcast that's coming out. We're recording next week. It'll be released at the end of next week, that we're with someone who's going to talk about the skinny on summer interns, and it will address that, other than to say, stipends are fraught areas. I don't know if you want to, in terms of, if you give someone a stipend, you may end up with just a badly paid employee.
That's a great way to put it. Yes.
Yeah. If you start, anytime you have an intern, you start giving them money, you're really, you have to be very careful that you're not turning them into an employee. And then the other question, we have a couple other questions. We're a little bit past 1 o'clock. We'll stay on for a few more minutes to answer some of these questions. Please, if you have to hang up, we understand, so we will not take it personally. This is someone who has, they want to hire a CFO as an independent contractor on a temporary basis. We talked about certain positions being so integral to the organization that they would almost virtually always be considered an employee. But what about that? You have people send temp workers all the time. How do you deal with that?
Well, I think that this again may sound like a distinction without a difference, but my question would be whether you're hiring a CFO on a temporary basis or whether you're hiring someone to perform the financial services that a CFO would perform. Those, financial services, legal support, those are, supporting in critical roles within an organization that are not necessarily the business that the organization is engaged in, right? So it is not unusual to contract for CFO services. I would just make sure to structure it in a way that is mindful of all these other factors. Is it someone who are you bringing them on a full-time basis for 6 months? That's going to smell like an employee, frankly. Are you bringing them on to provide certain services that you need to have done for, what you expect to be 10 to 15 hours a week, and they also are providing similar services to other entities or organizations? That could be structured in a way that makes more sense. These are really, obviously, fact-specific analyses, and so there are ways to make that work, but I would just be mindful of the fact that the idea is to bring on someone on a temporary basis, for example, while your current CFO is out on extended medical leave, just because it's not going to last for the duration does not necessarily mean that it can be a contractor relationship.
Okay, and then one further question about the hourly. Employees generally are paid on an hourly or salaried basis, and independent contractors are flat fee. But we have talked about the exceptions. You can have a retainer agreement with an attorney, or you could an attorney or a therapist or someone can bill on an hourly basis. I guess the answer is how, and then the answer may be it's a factor that tilts towards the employee relationship. But if that's the only one, then then don't worry about it. I guess that's the question. How heavy should it be weighed? Yeah.
Yeah. So, it's in virtually every contracting relationship, there are going to be a few of these factors that are falling in the wrong column, if you will. And as Regina said, if this is the one, I wouldn't sweat it too much. I would just be mindful of the fact that if you're paying someone an hourly rate to come and sit in your office and do work on site using your own computer, the organization's computer, and all of these factors are pointing in that direction, that'll just be, cumulative in terms of pointing towards an employment relationship. I also think this is one reason why it's incredibly important to have invoices from your contractors, because it's not just the number of hours that they performed at a certain rate. I mean, you have to have some way to calculate how you're going to pay these folks, but it should be, developed and designed new website layout and some description, at 1.5 hours at a rate of $50 an hour. So the invoice needs to spell that out, and suddenly it looks much more like a contracting relationship than an employment relationship, because they're actually detailing the services performed and the hourly rate at which they're performing those services and how long it took. So those are the ways that I would be mindful of structuring it so that you're not inadvertently raising more red flags than you need to.
Okay, and then I have one final question and one comment, and then please feel free to email me with your questions if you haven't, if we don't have time to answer them, because they're coming in pretty fast and furious right now. And the first is, someone said, change of wages, question mark, exclamation points. And I have a feeling that has to do with the notice of hire. And just to say that, yes, if any information on the notice of hire you gave to the employee under the notice of hire required by DC law, if any information changes, you have to give a new notice of hire. So every time if you have an annual raise cycle, like you give raises in January, or you give raises in July or whatever, then you're going to end up having to give everybody who got a raise a new notice of hire with the new updated information. So yes, sorry, didn't mean to alarm anybody out there. So here's the next one, the final question. Can an organization limit the number of hours a contractor works? For example, do not work more than 40 hours a week.
Absolutely. First of all, you can limit the number of hours that your employees work, just to be clear. Even though you have to pay them for all hours work, you can say you can't work more than 40. If they do work more than 40, you have to pay them, but you can discipline them. I think that's that's my own separate rabbit hole and soapbox that I'm constantly on. But you absolutely can limit the number of hours that a contractor is performing for you on any weekly or monthly basis. That's completely appropriate. You would spell that out in the contract so that all of the parties are aware that those are the terms and the conditions of the contract. But absolutely, you do not have to pay a contractor for 70 hours if your contract says that they are going to provide services not to exceed 30 hours in a month. That is absolutely within your rights as you're setting this contracting relationship up.
And just final one follow up. That would be appropriate if you're paying by the hour. If you're paying a flat fee, you have no document.
That's right.
Side. Yeah,
that's right.
Okay, with that, thank you, Sedina. Like I said, we have more questions, and I apologize. We just are going to be mindful of everybody's time. But thank you so much. And we are recording this webinar so that it will be available when we send the evaluations. You will get a copy of the link so that you can at least go back and listen if you thought you missed something. And then if you have any other follow-up questions, you can give us a call. We'll take a second to close out the program. You'll see the handout box for a copy of the slides. If you want to download them, you might take a moment or two to download them now. And with that, everybody have a great day. And Sedina, thank you again. We appreciate it.
Absolutely. I'm always happy to help. Have a good day, everybody.
Thank you.